Would you call that item, please?
Under Vice Chair Bartlett and Supervisor Nelson, adopt resolution to repudiate the sentence imposed by Superior Court Judge Marc Kelly in People v. Kevin Nieto Rojano, Orange County Superior Court Case Number 14CF1874, to formally rebuke, censure, and demand the resignation of Judge Kelly from the Orange County Superior Court and to make related findings. We do have one speaker request on this item.
Okay, is it Mr. Meyer?
Yes.
So I'll defer to Vice Chair Bartlett and Supervisor Nelson, who's going to tee it up, and then you can decide how you want to go with speakers. You probably should frame the issue. You guys want to frame it, Vice Chair Bartlett?
Sure. This involves a case where a Superior Court judge imposed less than a mandatory minimum sentence. It involved a very heinous crime where a 3-year-old child was sexually assaulted. And when this item came up before the judge, the mandatory minimum sentence for this type of crime was somewhere between 25 and 33 years. And the judge legislated from the bench, essentially, and imposed a sentence of 10 years instead of a mandatory 25 to 33 years. So that's where the item is brought before us today, because Superior Court judges cannot legislate from the bench. And this involves a matter of public safety, and as elected officials, our top priority is always public safety. And so we have, I think, several versions of the resolution before us today for discussion and presentation to the Board of Supervisors. Supervisor Nelson, do you want to continue with the discussion?
I always think it's a good idea to hear the speakers first, because if you don't, you will hear them rebut anything that you say that they disagree with usually. So I'd be happy to let Mr. Meyer speak.
All right, well, hold on, Mr. Myers. I haven't called on you yet, sorry. Let's frame the issue. What is before us today? Because it's my understanding you just passed out an amended version. I like to discuss the question presented. So tell me, because Mr. Meyer needs to know what we are even considering, and so does the rest of the public. So what, Vice Chair Bartlett, what is before us? We have something that was filed on April 10th, 2015 that I signed as a supplemental, and then you handed something out moments ago or before the start of the meeting, and then Supervisor Doe also distributed a document. I have neither read either. I've not read either. So could you tell us what are you asking us to vote on, please?
Well, I think we have two versions of a modified resolution, one by myself and one by Supervisor Doe for consideration by the board today.
All right, so let's describe, so the record's clear too. Let's mark these documents. So yours, how is yours distinguishable from his? Can we, how do I know which one's which? Is there something distinguishable between these two documents?
If I can assist?
Yeah, Supervisor Doe.
Yes. If you go to the last page of the resolution, the proposed resolution.
By Vice Chair Bartlett and Supervisor Nelson?
Well, it's probably, yeah, you can look at my red line.
This is
copy,
yours.
right.
All right.
You see there's the one with a Post-it note that says revised by Supervisor Doe.
Correct.
That's the latest draft from me, offered by me today. And the reason for the changes are.
Wait, hold on. You're not vested yet. Stand by. I don't mean to be disrespectful. I'm not. I'm just, Vice Chair Bartlett, why don't you tell us what changes you're proposing then from the original? Just tell us what the strikeouts or adds are. And can you just start chronologically looking, I guess it looks like on page 2, you have your first strikeout, right? Correct?
Yes, item number 1.
All right. So I don't want to read that into the record because that's the kind of language we didn't want to talk about. But it obviously, if somebody wants to pull the item, they can see it.
Okay, I have changes in item number, so under the now therefore section, it's actually items 2, 3, 5, and 6.
All right, so to be
Include
clear,
my
you're striking the
changes.
language describing the victim and how the crime was committed, that kind of what we are so used to in court, but the public finds offensive. So you're striking that on page 2.
Correct.
You're recommending we strike the word censure and insert the word denunciate in item 2.
That is correct.
You're recommending in item 3 that we strike the phrase "the judgment," and henceforth put the conjunctive between faithfully and fairly and strike wisely or competently and add in the public's interest under 3. Is that correct?
That is correct.
All right. And then 5, you want to strike the word endorse and insert the word support.
That's correct.
And you want to strike in paragraph 6, the last portion of the sentence, when they cannot obtain complete justice or protection from the judicial branch of government. Is that right?
That is correct.
Okay, so does that fairly describe all your changes?
Yes, it does.
All right. All right, so is there a motion on that at this point? Just for discussion? Are you moving it that way?
Well, I would, yes, I would
discussion?
make a motion for discussion.
Okay. Is there a second on that, Supervisor Nelson? For discussion? Okay, so it's been moved and second for discussion only. Supervisor Doe, why don't you weigh in, and then we'll call on the speaker.
Great. Thank you, Mr. Chair.
Okay, I apologize for earlier, but I wanted to get that on the record.
Sure. And with all deference to the Vice Chair, I just want to throw these considerations out, the proposals for your consideration. First of all, I want to start by saying that I strongly disagree with Judge Kelly's sentence. So we all, I think, are in agreement that we disagree with the sentence that was meted out by Judge Kelly. The question is, what should we say in our resolution to state our feeling? If I can go straight to the therefore part of the resolution, the first paragraph where it says the defendant was that Judge Kelly ruled that the defendant was not solely culpable or personally responsible for the crimes he committed. I looked through it should be an opinion, but it's not. It's called a sentencing analysis by Judge Kelly. And nowhere in there does it say those words. So in order to be accurate, factually accurate, we should change it to that the defendant's conduct was not violent or in callous disregard for the well-being of the victim. So if we're going to repudiate his ruling, we should go to the language that he actually used. So that would be the first change. The second paragraph.
Can I interrupt you real quick? Vice Chair Bartlett, let's stay in order, okay? So on that issue, or who assisted from county council in drafting it? Who? Who are you pointing to? Mr. Page? Can you weigh in on that? No, I want to know where he found that for the record and why you suggested that language in that particular. Because I have the sentencing brief, and if you could point us to something, or if you were using words to encapsulate that concept, maybe you could describe that.
Mr. Chairman, members of the board, Leon Page, Assistant County Counsel, Senior Assistant County Counsel. In reading the court's analysis, the sentencing analysis, the judge speaks of finding a level of punishment or imposing a sentence that is commensurate with the defendant's culpability. And in so doing, the judge suggests that the defendant himself was not the only person at fault for committing the crime. So that was the basis then of that proposal to repudiate that portion of the judge's thinking, that portion of the analysis that suggests that someone else was somehow at fault for what happened to this child.
Was that the reference, in your opinion, that the 3-year-old just happened to wander into the location where the defendant was playing video games?
Yes, to repudiate, to say it simply, the idea that somehow the toddler was to blame for the crime.
Okay. All right. So, Vice Chair Bartlett, on that point, Supervisor Doe has suggesting different language. Let me just read what Supervisor Doe is recommending. Number 1, wholly repudiate the suggestion in Judge Kelly's ruling that the defendant's conduct was not violent or in callous disregard for the well-being of the victim. That's a little bit different point about whether or not the defendant was solely responsible. So are you recommending that's your version stay in, or do you think you would be accepting Supervisor Doe's?
I think I could accept Supervisor Doe's language here.
You concur with that?
Yep.
All right. So we have concurrence on that point with the makers and the second. All right. Supervisor Doe, you want to go to your second point?
Yes, thank you. The second paragraph where it says rebuke and formally denunciate, And this goes to the concern I expressed last time about not misleading the public into thinking we have power where we do not. And the word formally implies that we have some kind of disciplinary power over the judiciary. So I would delete formally and denunciate. We can really denunciate anything or anybody we want, but when we're talking about the judiciary, an independent branch of government, we have to be very careful in that we are denunciating his decision as opposed to the judge himself, because only the judiciary has the power to censure or to discipline one of their own. And so if we can change the wording, and it's very minor, but to me it makes a big difference in my mind, to denunciate Judge Marc Kelly's decision as opposed to himself.
And we got that. I mean, I think that's very clear. Vice Chair Bartlett, are you accepting of that?
Yes, I am.
All right, concur? All right, thank you, Supervisor Nelson. Okay, we have concurrence on that. Let's go to item 3, Supervisor Dunn.
Demand the resignation. I am okay with it, despite maybe a difference of opinion, because we can demand anything we want. There's nothing wrong with us passing a resolution to demand for it. And there's no risk of misleading the public there in terms of any vested power we may have. So I'm okay with paragraph 3. But paragraph...
Hold on. Don't confuse the record. So you have a new 3 because you're striking 4. So you renumbered it in yours. So let's just stay consistent. So her 4 is your new 3. So let's just supervise. So you demand the immediate resignation of Judge Marc M. Kelly from the Orange County Superior Court. Those are the same. She has a little bit. You have the middle initial.
Okay.
All right. So there's no change there.
Yeah.
Correct? Okay. So that stays the same. So let's go back to your striking declare no confidence, because in her version it's in and your version is out.
Right. And my proposed change to paragraph 4 is this.
Use her numbering, her 3.
Oh, her 3. Okay. I apologize.
Yeah, because that's the model. We're using hers as the guiding.
All right. Then when we opine about the confidence in the judge, and then especially with going further to his ability to faithfully administer the law of the state, California, in the public's interest, we're making a commentary on a career, a body of work, a pattern of behavior that would support such a strong and damning statement. We disagree wholeheartedly with this decision, and we would dare to go as far to say it makes us question his judgment. But when we go further and we're now commenting on his ability and our confidence to administer the laws in general in the public's interest, I think we're now venturing into an area that is very speculative, that is based entirely on just an opinion based on one ruling. And so I asked my colleagues if you can look at this and see. It does not offend me personally. I just think that we are going out on a limb that is unnecessary.
Okay, and my comment...
Yeah, hold on. You're not next in line. Supervisor Nelson, if you want to, I'll recognize you. Just push your button. Supervisor Nelson.
Sorry. Look, we're way overthinking this. I think just the general point is the whole purpose. But ability might be a little strong. How about his willingness to faithfully and fairly administer? He probably has the ability to do it just fine. He doesn't seem to be willing to follow the law, which is why we're talking about it.
Okay, Vice Chair Bartlett.
Well, I could agree with that, or this is also redundant to some extent, because by demanding his immediate resignation, we're essentially saying that we don't have confidence in his ability to faithfully and fairly administer the laws.
I have a little bit different focus. I reread his opinion last night. I read the victim's testimony. I have the transcript here. I read the sentencing memo. That paragraph, demanding the immediate resignation, you're right. That's a very powerful statement by this board. It's in, at least at this point. But if you don't explain to the people why you're asking for that, that's the question presented. In other words, why would you ask somebody to resign? You've got to be clear in the prior paragraph that's in Vice Chair Bartlett's version that there's a rationale behind it. And I have to tell you, and I know Supervisor Doe, you're talking about striking it, I have no confidence, okay? I am so torn by the fact that a magistrate, a sitting magistrate, has tried to distinguish a violent sodomy as opposed to a sodomy that apparently is inherently not violent. I am so disturbed and troubled by that statement. And I'm really disturbed that the judge went to great pains. If you go through this, and he was obviously going through great pains because this is a difficult case where the defendant and the victim are from the same family, and obviously the parents are extremely torn based upon this public record. I'm not reading anything that's not in the public record. He decided that in order to depart from the statutory minimum, he would have to find that the sentence was disproportionate to the act. In other words, he had to minimize the act. A 19-year-old male brutalized a 3-year-old, and I have a judge on paper trying to minimize that act. So I have no confidence. And I feel horrible about it because I work side by side with that gentleman, not in the same unit, but we were relative peers as things go, as prosecutors. And so this is not easy for anybody involved. But the fact is, I have no confidence that a judge would try to distinguish sodomy, acts of sodomy, especially 19 versus 3. It's unfathomable to me. So I could not support this resolution unless 3 remains. Supervisor Doe. Well, anybody make a suggestion. I mean, if you know.
I did. I think willingness versus ability probably is more appropriate.
So what do you said strike ability and put willingness?
Right. It appears he's not willing to faithfully and fairly administer
He clearly
the law.
has the ability, right?
I don't have any question he has the ability. He consciously chose not to do it and spent great lengths to explain why he wasn't going to do it.
All right. Well, I in the spirit of trying to get a resolution here, I don't think that goes against anything I said in terms of willingness. Ability is like second guessing his inherent, innate intelligence or passion or something, which is second guessing. It's not speculation if you go with Supervisor Nelson's wording. So, Supervisor Bartlett, are you comfortable with that?
I could live with that. Would like for Supervisor Doe to weigh in on this as well.
Would you like to be heard?
I have permission to speak?
You sure do.
Okay, thank you. No, that suggestion is a good one from Supervisor Nelson.
So you're okay with that?
Yes, I am okay with it.
All right, great. So 3 will stay in with 1 strikeout of the word ability and the insertion in its place of the word willingness. Supervisor Doe, then we're back on number 5.
I'm okay with the rest of the resolution.
Yeah, it looks the same, right? Support the decision of the district attorney to pursue appellate remedies. We took out endorse because we don't really have the ability to endorse that. We support it, and we reaffirm, and we strike the last sentence. So, okay.
Correct.
So,
I'm good.
Madam Clerk, do you have all those changes, edits, deletions? All right. So now that the record, thank you very much, Mr. Page. The floor is yours, Mr. Meyer. Now that you understand exactly, you see why I want to have this conversation before you spoke?
Oh, absolutely.
Yeah, so now you're very clear what it looks like the board would be willing to support. I know you still have objections, but at least you're clear on what we are asserting. So please, the floor is yours. Go ahead.
Thank you. Paul Meyer, speaking on behalf of the Orange County Criminal Defense Bar Association and in line with the principles as we described earlier with, we think, of the judiciary. Thank you very much, Mr. Chairman, for taking the time to read the record. I'll be very specific. I have a problem with the resolution, and I have a problem with the resignation, calling for resignation. Let me tell you why. This case is on appeal. You are making a resolution calling for a judge to be denounced or denunciated and calling for resolution or a resignation based on an act he did. In other words, it's a legal decision that he made, judgment made in a legal case that is now on appeal. Ask yourselves, this case is on appeal. You can't stop it from going on appeal. It's on. What are you going to do if the Court of Appeal, 3 justices, who review the record, because they've reviewed all the record, they review the facts, What if they agree with Judge Kelly's decision? Now, we can't know what's going to happen in the Court of Appeals. Will you, as a body, be comfortable sitting here calling for the resignation of the justices of the Court of Appeals? And in the event that the case moves and they sustain the judgment of Judge Kelly, we understand you disagree with it, the heinousness of the crime, not in dispute. It's the independence of the judiciary and this body's obligation to follow those cases. What do you do at that point? I think the resolution puts the board in a very uncomfortable and unprecedented position, because you will be having speaker after speaker, columnist after columnist asking you, well, are you now calling for the resignation of the Court of Appeal? And if that case is taken up by the Supreme Court and they conclude that the Eighth Amendment, as applied in this case, was in fact correctly applied within the discretion of the court, made a reasonable and rational decision, if that's their decision, will you call for the resignation of the California Supreme Court? And of course it will move, won't it, to the Supreme Court, because the Eighth Amendment is a constitutional imperative. This board has never taken the step of injecting itself into an appellate process and appellate decision. We heard several times this morning how respectful the board has been for what has been decided by courts of appeal, what you have to put into a contract and how you put it into contracts, and all of those issues. Agreed, Judge Kelly has a tremendous, strong history. He's got a great decades-long service and good judgment, but this case you disagree with. You may be right. You may be wrong. But it's not going to be to this board to make that decision. It's the Court of Appeal. So I ask you humbly to take a step back for a moment and ask yourselves whether or not you think it's appropriate for the Board of Supervisors to effectively make a direct statement to appellate court justices. You better make a decision that we like, because if you don't, we will be doing the same thing to you that we're doing to Judge Kelly, which is calling for your resignation.
Mr. Meyer, you need to wrap it up.
I'll wrap it up.
Yeah.
Please take a step back. Don't inject yourself into an ongoing appellate process. Review it for a moment and ask yourself if the system works, as we've heard that it does, and when it does, it's terrific. Let the system work.
Thank you, Mr. Meyer.
Thank you.
All right, let me say a couple of things. I'll call my colleagues. First of all, I worked feverishly for John Adams to defeat Judge Klein when we found child pornography, or I didn't, but somebody in law enforcement or the Superior Court found child pornography on Judge Klein's court computer. And we led the charge, and we actually got John Adams the first successful write-in campaign as a write-in candidate to get on the ballot here in Orange County, and he actually, that was in the primary, and then Judge Adams went on to win, and the woman's name is escaping me, it's been so many years, but the point is, then he won in November, his name got on the ballot in the March primary. We have been activists. I was a county supervisor when Judge Klein was found with child pornography, and I found that despicable, and that's why I took a very, very personal and active role as a county supervisor in recalling a sitting judge. So under the argument that I just heard, what I should have done as a supervisor is wait until Judge Klein went in front of the Judicial Council, or he was admonished, or he was prosecuted. I really had to sit on my hands and wait. I don't think I have any obligation. That's number one. Number two, it's not the sentence which is the motivation for my acts. Let's look at the eye on the prize. So many people want so many of us to focus on the legal issues of whether or not the 25 to life minimum is during sentencing there could be a balancing test about the constitutionality, because somehow it shocks the conscience or the punishment outweighs the gravity of the offense, which is basically the Eighth Amendment test. It's not so much what the Court of Appeal rules. Even if they reverse Judge Kelly, I wouldn't change my opinion at all, because it goes back to the original point. He tried to distinguish in writing how this sodomy was different than other sodomies. That in contrast, because this little girl was in a home and she wandered into this playroom where the defendant was playing video games, that somehow that's different and distinguishable than whether she was abducted like Samantha Runyon from the front of her house, abducted and then murdered. Really? So we're going to play those kinds of games when it comes to a 3-year-old versus a 19-year-old in our society. So in my opinion, I told David Whiting, and I think, Paul, you were in the same article by columnist Whiting on Sunday, it's not the sentence that causes Judge Kelly's demise, it's the words he chose to distinguish the case. And so that, to me, is the reason I support his immediate resignation and the recall if he chooses not to step down. Supervisor Nelson.
I wrote it down, so I didn't take notes when you were speaking, but I could have. Listen, for the critics, I don't care if the Chief Justice of the Supreme Court refuses to follow sentences of imposing death. That person can be recalled. And as a citizen, I have a right to disagree and recall that individual. And it happened in my life. I wasn't old enough to vote then. I disagree with a judge in Orange County finding, pure and simple, that a forcible sodomy on a 3-year-old is not a violent act. And that is his finding. That is an impossibility. And I don't care who makes a legal finding that there's some differentiation. There's not going to be a legal finding as to that anyway. The legal finding will be some unique analysis of cruel and unusual punishment. I am not going to stand for anyone, judicial or otherwise, in an elected position in this county, making the claim that forcible sodomy on a 3-year-old is somehow something that you could mitigate and explain away. You can't. And I don't care what court gets to opine on this subject. The fact of the matter is there is nothing but violent sodomy when it comes to 3-year-olds. A subject that I think we can generally universally agree on, with the exception of Mr. Kelly, who apparently has some bizarre and unique exception. And it was purposeful because he's somehow begging to find a result that the law doesn't allow. And the bigger trouble I have, just being a critic of Mr. Kelly, is if Mr. Kelly wanted to uphold his duty, Mr. Kelly could have just sentenced to the legally mandated minimum and written the same exact opinion and said, I don't like that this goes down because I believe I should have some latitude. And he could have put it in the hands of those who are charged with figuring out this constitutional dilemma as he saw it. I don't see it. But what he should have done, he didn't do. But Mr. Meyer, I have nothing but respect for you. And I know you have a challenging job. And I appreciate that you've come here twice, which is your right as well. I just want to suggest, that this whole idea that somehow people will be challenged with their limit on civics, there is, I don't really believe, an actual misunderstanding. When you talk about separation of powers, Congress is separated from the president. We all kind of got that in high school civics. Congress is not separated from the governor of Vermont. That's not the kind of separation of powers anyone's talking about. There's no separation of powers to discuss when you're talking about the City Council of Costa Mesa or the Board of Supervisors and the judiciary. The judiciary's separation of powers is between them and the governor's administration. That's the separation of powers. We have nothing to do with that separation of powers. We don't have any say over their budget. I haven't checked your bar card. You may have practiced, Mr. Meyer, long enough to have been around in the time when the county did have a say over those things. Before the combined courts and back when we had municipal court and all that stuff. But that's not even our circumstance anymore. So just completely misleading to talk about separation of powers. And for the civically challenged, maybe it sounds like there's supposed to be a separation of powers. There is. It just doesn't have anything to do with this circumstance. We have no authority over the judiciary. And although there may be sort of a long line of people that don't quite understand that nuanced detail, I am overly confident that every member of the appellate courts in California and beyond certainly know that they don't have to do or be affected in any way, shape, or form by what we say. And I think to suggest that they fail to understand that, kind of an unfair swipe at them. Of course they understand that. They know very well that our opinion is just that. It's just an opinion. We don't make a habit of doing this, and that's a good thing. I'm not a big fan of resolutions in general. I said a week ago, this is a unique circumstance. It's the extraordinary exception. It's not the rule. There's no slippery slope. There's no need for the sort of, Otter's Animal House speech that if you're going to indict the United States of America, we're not going to stand for it, and we all kind of leave the room humming as we walk out. There's no slippery slope here. I mean, I appreciate you always kind of go to the great lengths to make that argument. There's no slippery slope. There's no chance that we're going to end up talking about this again with every decision we disagree with down the street. There's decisions in an abundance every day we disagree with. That's what kind of makes it fun and what gives every member of the bar a challenge. This is not that case. It never was. And any attempt to characterize it as anything but an extraordinary exception is just sort of purposefully misleading. Anyone that's ever followed our meetings, some of you in this room have done so for a long time, this is very rare, as it should be. And this case warrants exactly what it's getting, a rare bit of attention to say, we have a community standard here, and anyone that has the authority of a judge that's going to stand up and justify to a father of 2 girls and 3 kids that forcibly sodomizing a 3-year-old is somehow nonviolent, I'm going to win that argument. I believe overwhelmingly public agrees with this board and vehemently disagrees with the competence of anyone willing to make such a ridiculous statement as Judge Kelly made in this case. His words. He wants to mitigate and minimize forcible sodomy on somebody's baby. And I'll be darned, what a shame that the very person that happens to be the mother of that baby is also the mother of the 19-year-old. What a horrible dilemma for that poor mother. I don't discount her concerns, and I understand how is she supposed to make sense of all this? She can't win no matter what direction she turns, and none of us are unsympathetic to her. But as a father with perspective and an understanding, this judge needs to be censured by hopefully a lot more than this board. What this person did is outrageous. And for whatever his reasons, he is a smart man. And he knew darn good and well what he was doing and why he was doing it. And in reading his words, it was purposeful. And it's from what I've read, to allow that person to remain on the bench is dangerous. Because what he's telling me with a big red flag is I have a desire to do what I want to do, despite what the law tells me. And even when it comes to forcibly sodomizing a 3-year-old, if it's in my best interest as I see it to mitigate that, then I'm going to do it. I don't care that just the clear black letter of the law says there is no mitigation for raping 3-year-olds. And the appellate court can weigh in all they want, but the appellate court has dealt with minimum mandatory sentences, and they are legal.
Yep.
So, if Judge Kelly wants to argue that, God bless the man. But he's in the wrong job for that. He should have gone to the State Assembly with, Senate with my other 3 colleagues that are there right now. Plenty of opportunity to, opine on how the law ought to work in this state. But the bench down the street from here is the wrong place to make the decision he made. And we as a society are asked, as opposed to federal judges, we're asked to hold these people accountable. All of us is the we. We're all asked to hold these people accountable, and they are. And he is going to find out that despite the fact he has some supporters that I respect, the overwhelming majority of us disagree so much that we are going to be forced into action that we would prefer to not take. And if he cares about society, I just hope he does the right thing and spares us all the effort and resigns. It's what he ought to do. It was his actions that caused this, no one else's. And he will have to live for that for the rest of his life, whatever he does. Thank you.
Thank you very much. Supervisor Doe, then Supervisor Bartlett, and then we'll close. Supervisor Doe.
Thank you. The facts of this case are horrific, and I don't need to recount them. But I think one thing that we need to focus on in some of their comments about why this board should not take this action, I think sometimes people forget that as a executive branch of the government, we give voice to the people we represent. Now, to the degree that in the exercise of that voice, we somehow influence the judiciary or seek to influence the judiciary, we would be overstepping our boundary. But we're not doing that. We have taken great pain to not do that, to not give the appearance that we are trying to do that. And so I think any comments or criticism that this action, this resolution is somehow overstepping our boundary, I think misunderstands the structure of our government in that we represent our constituents, and we, by taking this action, give voice to our constituents. And no more, no less, it's just a voice to express how we feel about what happened. I think Supervisor Nelson was very eloquent in distinguishing the things that people could do if they disagree with the law. And I know that judges have a very difficult job interpreting the law and sometimes applying the standards on something as complex as the Eighth Amendment against cruel and unusual punishment. But that doesn't mean we are prevented from voicing our disagreement when we feel, in a case like this where it's warranted. And so I have no problem supporting this. In fact, I wholeheartedly support the board taking a step to express our feeling about this case, because I think the feeling is so universal that we're not going out on a limb here at all and trampling on something that is perhaps tenuous in terms of the basis of the court's action. And so I applaud our board for doing this, and thank you for accommodating my suggestions earlier. Thank you.
Thank you. Your insights and some of the changes you recommended, I think, were stellar. I'm so proud of this board working collectively to try to make better public policy. Vice Chair Bartlett.
The five of us here on the Board of Supervisors collectively represent the 3.5 million people who live in Orange County. And the public has spoken, and they are really outraged about the judge's ruling and his comments that they find callous and offensive. When Judge Kelly stated that he decided unilaterally to reduce the sentence from a minimum of 25 years to 10 years and stated that the victim wandered into the garage. The perpetrator did not seek out the victim. Therefore, it shouldn't be a minimum 25 years. And also that this was the first crime committed by the perpetrator. Well, for every sexual offender and every sexual predator out there, there was always that first time. And so in looking at the case, the judge, what he should have done is indicated to the defendant, well, I don't agree with the minimum 25-year sentence. I must impose that because that is pursuant to state law. And he cannot, a Superior Court judge cannot change state law. He doesn't have the option with the penalties in this case to impose a sentence less than 25 years. He can't pick a number of 2 or 4 or 8 or 10 as he did in this case. The smallest number was 25. And that is a real problem when the judges don't uphold the law and they legislate from the bench. And so I think the public has really spoken out on this issue. They're outraged. And the Board of Supervisors before us today, I think we have a well-crafted resolution, and I hope we move forward on this.
All right, thank you very much. I'm going to close on this issue by reading the words of the actual opinion, okay? This is the actual opinion. And I'm not going to use some of the words because they're inappropriate for this venue, although they are appropriate in a court of law. But if these words don't make you cringe and shudder or raise the hair on the back of your neck, you are not a human being. However, in looking at the facts of Mr. Rahano's case, the manner in which this offense was committed is not typical of a predatory, violent, brutal sodomy of a child case. Mr. Rajano did not seek out or stalk his sister. He was playing video games and she wandered into the garage. He inexplicably became sexually aroused, but did not appear to consciously intend to harm his sister when he sexually assaulted her. As noted by defense, in an instant, he reacted to a sexual urge and stopped almost immediately after he put his private part into his sister's private part. Within seconds of commencing his offense, he realized the wrongfulness of his act and stopped without completing the act. Although serious and despicable, this does not compare to a situation where a pedophilic child predator preys on an innocent child. There was no violence or callous disregard for his sister's well-being. We have a motion and a second. Any objections, colleagues? Passes unanimously. All right, we're going to go back to the top. We're back at item 21.
Under Healthcare Agency, approve agreement with Pacific Clinics for Recovery Education Institute Services and authorize director or designee to execute agreement.
I just need to, let me just check my, excuse me, just 2 seconds. All right, colleagues, any objections on 21? All right, passes unanimously. Thank you. 22.